Rebecca is coming from the University of Manchester, where she's been lecturing for a while. She did her PhD at the European University previously, and for maths studied at the University de Nanterre. And her topic today is quite close to the forthcoming book of Cambridge University Press, and also the topic of the PhD thesis. And it's something, one would think we'd have heard about quite a lot in this faculty. I don't think we've had a presentation on drones for a very long time. And so, Rebecca, we very much look forward to hearing you, and
thank you so much. Thank you for having me. Is it fine? Are you comfortable if I remove my mask while speaking? Okay, that's great. Thanks a lot. So yeah, as Frédéric told you, this is a forthcoming book, but it's not completely finalized. So if you have any comments or feedback, I really welcome it in order to implement it in the book and refine the argument further. And the book that is called Drone Programs and International Law, a Techno-Legal Machinery, really tells a story about how war, technology, and the law interact and reshape one another. So looking at the law, military strategy, and technologies as important interrelated factors. So it's not only how human beings decide to use the technology, but I argue that the technology, there is something special in the technology in reshaping military strategy, the way we conduct warfare, and in putting some pressures on the legal frameworks regulating the use of force, or at least calling for a new or a series of new interpretations of the law. So studying how drone programs are assembled is both, I think, a descriptive and critical endeavor. What I propose in the book is really a history of the present, of how the law is transformed through countering future threats. So through using new technologies in order to anticipate threats and identify dangerous individuals. So the series of questions I asked myself is, first, is there something special about drones that explains the intensification of the pressures put on the international norms regulating the use of force? So jus ad bellum and jus in bello. How do legal technology, legal narratives, technology, and military strategy interact and reshape one another? And finally, what does this interplay bring about? What reality does this interplay create? So what I demonstrate is that drone programs have exploited, maybe I will go there so that I can also look at the slides at the same time. So how drone programs have exploited legal uncertainties to bring about a new kind of warfare. One that I described as individualized and dematerialized. These are a little bit difficult to grasp concepts at first glance, but what I want to show through these two concepts is that basically what is aimed at is to identify dangerous individuals in advance of the threat that they would pose, and the trigger to use force is not anymore an armed attack, for example, if we look at the jus ad bellum paradigm and the right of self-defense, or if we are in the jus in bello paradigm, we're not looking at signs of direct participation in hostilities. So these material acts are not what trigger the decision to use force anymore, but it's really characteristics that are related to the individual or to his behavior. And I use his on purpose, of course, because you must have heard about these categories of military-age males that have been used by the US, but also by France in their use of force in the counterterrorism context. Maybe a disclaimer that is important to make at first glance is that this is not what I'm describing here, is not the lege lata, so it's not the law as it is. Rather, it's a series of interpretation of the law that are pushed or that are proposed by a handful of states active in the war on terror. And the three case studies are the US, the UK, and France. Probably we have heard a little bit less, but to respond to what you were saying, Frédéric, it's We have heard less about the US drone programs, first of all, because it has been institutionalized and normalized, so it's stable. And second, when we're looking at France, it's something that has been much less debated, both domestically and internationally, and I respond to this gap with this, that this is just a parenthesis. So as a result of the detachment from material elements of the threat, the armed attack or the participation in hostilities, what I show is that the war that results from this is indefinite, both in time and geographically speaking. So the temporal and geographical scope of war has been extended through the use of drones' technological capacities and through the related legal rationales. What I observe after this is that this indefiniteness of war is further enhanced when we look at institutionalized drone programs. And this is particularly the case, of course, and this is the comparison that makes sense between the US drone program and the French use of drones, is that one is at a high degree of institutionalization. And this is what I look at when I focus on the US drone program and the bureaucratic machinery that accompanies the use of drones. And so finally, I analyze both quite concretely on the basis of several elements that I have not necessarily gathered myself, but that have been put together in other studies, how the use of drones infiltrates bodies of populations living under drones. And through this analysis, this very concrete analysis of how behaviors and traditions are reshaped through the use of drones, I make a claim that these are rituals of sovereignty, and I will unpack these different points. But rituals of sovereignty that are exercised over populations living under drones. So I think that if I had to map out the different contributions that I make with this study, the first one would be to reestablish the importance of the technology. So in most legal scholarship on the use of drones, there has been a denial of the importance of the technology. What matters, basically, it is argued, is how we decide to use the technology. And it's almost irrelevant to look at the technological capacities and the way in which they have potentially reshaped our way of conducting warfare. And in response to this denial, I show that the individualized warfare that I was telling you about is facilitated and intensified by drones' technological capacities, but also that the related legal rationales are made more acceptable. So this series of propositions on the use of force, both in the ad bellum paradigm and in the in bello paradigm, are much more acceptable, even though they are pushed for by a handful of states only. The lack of reaction, I argue, by the international community, or the fact that very few states have been vocally arguing against this series of legal interpretation of the right of self-defense, or I will come back to this later, but direct participation in hostilities when it comes to in bello, is arguably because of drones' technological capacities that make it more acceptable, or that make the idea more acceptable that it's fine to anticipate threats and to interpret the right of self-defense in a very extensive manner. So rather than waiting for an armed attack to trigger the right of self-defense, then to have this kind of legal constructions and creatures in the name, for example, of continuing imminent threat that you might have heard of. And I'm happy to come back to this in the discussion that we'll have. The second contribution of the book is that it was because it was initially ruled out, I believe, by legal scholarship that there was anything special to drones' technological capacities. The broader and long-term effect of drone programs has been underexplored. So this is the first reason. The second reason is because most debates have focused on targeted killings and drone strikes. And very few scholarly works have really focused. There have been some that are greatly important, but it has been neglected that there is a whole surveillance apparatus that comes with the drone program. In fact, based on discussions that I've had with drone operators in the US and in France, you understand that 99% of the time of their time is spent monitoring individuals on the ground, and only 1% consists in conducting a strike. And therefore, the fact that the discussion has really focused on the moment of use of force and not what precedes it or follows it has led to this neglect of the broader and long-term effect of drone programs for populations living under drones, but also on a more theoretical point of view for the international legal order. The third, and you might have understood it already, what is useful in looking at the argument that I've made is that all of a sudden you have not only a study of the US drone programs, but also of the French and UK use of drones. And this has required, and probably this is linked to the last contribution I identify in the book, which is because the fact that it has been underexplored is that studying is actually quite challenging in terms of sources and materials and evidence. First of all, because most of the drone programs underpinning or underlying legal rationales, except for the US, is confidential. So France has much less of a legal or of a constitutional actually tradition to expose their the government's legal interpretation of, say, direct participation in hostilities or the right of self-defense. So first of all, there is the question of tradition. Second, a lot of information is classified, of course. Third, there is a struggle to collect evidence. Drones are used sometimes in very distant territories, in states that are called failing states, for instance, and that might understand very late that a drone strike has taken place, and then the collection of evidence is quite a challenge. And then, as I said, there is silence on what is the military strategy and how the norms are interpreted. So this pushed me to use a multiplicity of sources. So from databases of independent journalist organizations, you must have heard also of forensic architecture, cartographic work on drone strikes. This has proved quite useful. Parliamentary debates, informal discussions that I've had with people who have participated in putting together the Obama drone program, but also in France, people who are part of the conversation on how drones are used in the Sahel. This is also why I believe it's a quite relevant topic on a more engaged level. You must know that France is involved in the Sahel since 2013, and that drones have been used since 2019, and so the fact that it's understudied is quite problematic. And it's linked also to the lack of translation of these parliamentary debates that I use a lot in the book. So in this sense, you might think of this book as an act of compiling a lot of sources, textual, bureaucratic, and material traces of these programs in order to lay bare the infrastructure that is extending warfare and exacerbating state power in the form of what I call rituals of sovereignty. Don't hesitate to interrupt me, of course, although I will keep a good part of this session to discuss. So if I guide you through the different steps of the argument, the first chapter is dedicated to studying the process of institutionalization of the US drone program. And I compare it, of course, with the lesser degrees of stabilization of the use of drones in the UK and the use of drones in France. And what I show here is maybe something that I can identify or emphasize earlier is that I was not interested in the study of drone programs because I was interested in the state, so the very technologized state. So it was not motivated by a desire to study the state. But I must say that the state and its bureaucratic infrastructure imposed itself to me very early on in the research. So when you scrutinize drone strikes in the US, you understand very quickly, you must have heard of the drone papers that were leaked by The Intercept. You understand quite quickly that the sophisticated legal rationales that were put together and articulated by the Obama administration were accompanied by the stabilizing force of technology, but also of a very sophisticated bureauccy, procedures, staff dedicated on a daily basis, not only to justifying drone strikes, but also to activating at every step of the process a decision to kill, in the form of what we have called targeted killings on the one hand and signature strikes on the other. You must be familiar with this distinction. So when I look at how legal rationales and technology have normalized and stabilized the bureaucracy, I focus on the role of the law. I make an argument about the role of the law in developing the US drone program that can be understood in different ways, and I'm happy to extend it further later because there is a theoretical argument about why I think the way in which the Obama administration used the law was quite successful and sufficiently successful for the counter narratives, for the counter legal narratives developed or deployed by NGOs, but also by legal scholars to fail in the face of this type of legal arguments. To be a little bit specific, what I believe was quite successful was that the legal rationales of the Obama administration were presented as possible interpretations that are allowed by the semantic framework of the norm. So the norm has a certain semantic framework, and they just exploited the spectrum of possibilities within the norm, within this semantic framework. And therefore, they were not making an argument about this is the right, this is the true interpretation of the norm, but this is just one possibility. And there is here a reasonable disagreement about the interpretation of the norm. And this is what we push for in this specific context, when it comes to the use of drones in particular, when it comes to countering a new type of threat, the jihadist type of threat. And what was quite interesting was to see how the response from legal scholars in front was more of a reference of what is the true interpretation of the norm. So this is not, for example, anticipatory self-defense is not a possible option with regards to Article 51 of the UN Charter. So there was kind of a debate that was taking place at different levels, which I think was also made the strength and the success of the sophisticated legal rationales of the Obama administration. In the three, I end this first phase by testing the hypothesis of institutionalization by showing that there is an interchangeability of the bureaucrats. So the US drone program has bureaucrats, I argue, and these are interchangeable, up to the president of the United States. And here I nuance all the claims that were made that the drone program under the Trump administration was different, that important thresholds or requirements were abandoned under the Trump administration. Well, I argue against this, and I demonstrate, I believe, that this is a myth, basically. The myth that the Trump administration dropped crucial legal and policy limits that Obama had imposed on drone strikes is flawed. And I show this from, of course, Obama to Trump and now to Biden. So bureaucrats in this institutionalized drone programs are interchangeable. In the 3 next chapters, I zoom in a little bit. I don't know what you all work on, but I believe it's interesting to highlight that I change my point of view. So at times I have an external point of view, and I look at the interaction of these different technological, so human and non-human factors together in an actor network theory type of way. So I have an external point of view. And at other points, I have an internal point of view. And this is pretty much the case in these 3 chapters, when I zoom in and conduct also some kind of doctrinal analysis of the interpretations that are proposed, both in terms of ad velum and in velum. So I delve into here the ad velum justification for drone strike and the extensive version of the right of self-defense. And what I demonstrated here is that the technology and the legal rhetoric are used as instruments to authorize action against individuals who are not seen as perpetrating an armed attack, or even imminently so, but who are identified as posing a threat, right? Who have a certain behavior that tells us something about the fact that they belong to a hostile group. So identifying by intent. And what I show here is that even if some limitations remain on the right of self-defense, so moving from one criterion to the other, one requirement to the other, that these are interrelated as a cascade effect. So once you abandon the armed attack limitation, for example, it then has consequences on the temporal scope of the right of self-defense. So I show how these are interrelated in a cascade. And I show that, and this is where the actor network theory point of view is relevant again, I show that this chain of propositions on the right of self-defense is not just an outcome of bureaucrats proposing certain interpretations of the right, but also what technology allows them to do, basically. So I argue that by allowing individualized data collection, by allowing permanent presence over areas that are observed through the lens of the drone technological capacities make the legal authorization to use force in anticipation of threat more acceptable. So this is where I argue that the technology has a weight in this in the acceptance or acceptability of these legal rationales. And actually, when you look at reactions to different uses of the right of self-defense, or in other contexts, a very recent one, of course, in Ukraine, you can see that when the technology is different, and when there is another factor that I look at this network of factors as well, which is the type of enemy that is being fought. So when you look at this interaction of factors, the legal rationale is made more acceptable, or at least it leads to less reactions and criticisms. When the same propositions about the right of self-defense is used in other contexts, such as the recent one in Ukraine, there is a reaction from the international community that this is not an acceptable interpretation of the right of self-defense. So again, this is not to say that the extensive version of the right of self-defense is the law as it stands in a transcendental manner today. I believe that different interpretations of the right of self-defense crystallize and coexist at the same point in time, depending on the situation. So just to clarify. Moving to an in velum framework, I then explore how the jus in velum, its uncertainties, as well as its new interpretations, and I will go back to the direct participation in hostilities that I mentioned earlier, authorizes the extension of enmity in 3 ways. So extension of enmity to the broader network, so members of a broader network of jihadist groups. To new groups as well. So this is what we have heard through the Al-Qaeda and Associated Forces framework in the US, but also in France, and this is less known, it's a paradigm of war against jihadist groups. So when you look at parliamentary debates, but also laws on military programming, you see that the war is framed as a war against jihadist groups. So it's arguably even more extensive than Al-Qaeda and Associated Forces. And finally, the extension also to members that are of terrorist groups that are far from conflict zones and that haven't really suffered the war paradigm so far, but I don't exclude that it might be the case in the future. So extension of enmity basically to three types of enemies. And this extension of enmity, I argue, is facilitated not only by the legal uncertainties related to the endpoint of armed conflict, but also to new interpretations of the norms. So you're familiar with direct participation in hostilities, I suppose, in IHL, and its new version of continuous combat function. So it's not something that arose actually in the discourses of, it didn't arise first in the discourses of states active in the war on terror, but the idea is that you can extend the targeting possibilities beyond moments of active participation in hostilities, even without having witnessed such participation. When you have identified a series of elements, circumstantial evidence or behavioral elements that tell you that someone has a durable integration into a non-state armed group that is sufficiently organized and against which violence is sufficiently intense to consider that we are in the framework of an armed conflict. So I argue that this continuous combat function aligns with the practice of signature strikes. Signature strikes that take place when behavioral and contextual elements are gathered together and show that someone is possibly durably integrated into an armed group. In particular, I highlight that what leaves room for this possibility is the test as currently defined by the ICRC in its interpretive guidance. And the idea that someone can be considered as holding a continuous combat function, even if he or she has not shown or has not been witnessed as participating in hostilities. So this, I argue, aligns with the practice of signature strikes. And again, I argue in this actor network theory type of way that it's only because the technological capacities make us think that we can identify dangerous individuals or individuals pertaining to terrorist groups that this type of test is made acceptable, and that this type of practice is arguably appears at least as more acceptable. So in a world where a drone was not equipped with the capacity to observe on an almost permanent basis individuals living in the drones, where there wouldn't be a possibility to collect data, for example, GPS or all sorts of data together and corroborate them and identify someone as possibly pertaining to a terrorist group. I argue that this version of the continuous combat function test wouldn't appear as acceptable. There's something else that I want to say, but I forgot. So still in the in bello paradigm, I move on to talking about not only the temporal, because the third one is the extension of enmity, of course, in time. So targeting individuals before the threat has materialized means that you have an indefinite warfare in time. when it's about threat anticipation. And then I move on to talking about what allows for this anywhere war to take place. And again, looking at the way in which the law, the legal uncertainties, and in particular, the absence in the law of geographical delineation of conflicts and technological capacities allow for such an anywhere war to happen. So of course, you must have heard about these debates, and these have been common debates about drone wars since, especially since it intensified under the Obama administration. The whole debate about whether or not there is a geographical limitation of conflicts. So here, very briefly, I argue that there is no such legal geographical limitation of conflict, that it's used to correspond. So the geography of conflicts used to correspond to what we call non-international armed conflicts on the one hand. So it's used in practice, in fact, to correspond to a type of conflict that was delineated to the territory of a state, but that this was just a matter of fact and not a matter of law. And here, going back to the extension of enmity, the fact that transnational non-state armed groups in the counterterrorism context have multiple centers of gravity, combined with the fact that the technology is focused on threat anticipation, or is at least follows a strategy that is threat anticipation, leads or builds the possibilities of an anywhere war. So this is not so much anymore about a certain legal interpretation that allows or that aligns with this practice, but rather an absence in the law of geographical limitation. So finally, in this last chapter, I ask what it implies, as I told you, that drone programs are implemented in the normal functioning of the state. And I show that when institutionalized, drone programs infiltrate bodies and minds of populations living under drones. Through repeated practice, populations living under drones identify or create a mental map of the profile of an individual that is typically a drone target. This we have seen, of course, in the context of Afghanistan and Pakistan, and great reports have been made about this. But you can see it also progressively in the Sahel in France. So even though you have in France a lesser degree of stable or institutionalization or of the use of drones, you do have patterns that start to emerge of what is the typical drone target, or what can be the typical drone target. I don't know if you've heard, but there was an important event a year ago, a little bit more than a year ago, in the village of Bunti in Mali, with individuals who have been who were targeted while they were attending a wedding, very much recalling the type of strikes that were conducted in Pakistan. And the reason for this is that these individuals follow traditions and rituals where men and women are separated for a good part of the day, and then they had been identified as military-age male. Not only this, but they were also located in a territory that was known for hosting a number of terrorist groups, and therefore corroborating these different elements, the decision to strike was made without having, as I told you, witnessed participation in hostilities, but aggregating these contextual and behavioral elements. So of course, you see populations, and I work very closely with a journalist who goes on the ground in the Sahel, and through him, I managed to gather also elements of how the lives of individuals, especially in the village of Bunti, since the strike took place, have been reshaped already. So rituals of wedding have slightly changed because there is this mental map that is created of the typical, or what can be, because The point is not to make an argument that these states necessarily conduct strikes this way, but the mere fact that it can happen, of course, affects individuals living under drones. And this, of course, is almost an irony when you understand that the fleet of drones in France is quite small. And this has been also emphasized by proponents of arming drones in France, that it was a very small fleet and therefore we wouldn't see the effects that took place in the US drone program. Well, in fact, you can see through empirical evidence that no matter how small the fleet is, if the same type of practice or the same type of military strategy and anticipatory warfare is conducted through drones, it does have effects on populations living under drones. The reason why I talk about rituals is to refer to the symbolic and repetitive dimension of combat drones action that shapes and affects human behavior and activity, to refer to the fact that new habits are established through what we could call the psychological matrix that results from the use of drones and the experience of this ritual of power, basically, right? Populations living under drones. I renamed rituals of power into rituals of sovereignty simply because I want to emphasize how the way in which, or what we could call in a Freudian way, the governmentality that it allows. So when a certain state practice conducts behaviors and infiltrates bodies and shapes the way in which people live, you can arguably say that these are extension or modes of extension of state power. And of course, the reason why an international lawyer uses sovereignty rather than power is simply because then I use actually human rights court case law on extraterritoriality to argue that actually, even legally speaking, if you look at the drone program, not just in terms of drone strikes or targeted killings, but if you look at the broader surveillance apparatus that accompanies drone programs, then you can say that these are elements of governmental authority, to take the language of the ECHR, and public powers, which are normally exercised by the sovereign government, the host state, and that are through drones operated at least in some ways by the operating state. So referring back to the first part of the book, I conclude on the one hand that this expansion of state power through drones affects the territorial states, which are tamed through legal creatures such as unwilling and enable, the unwilling and enable doctrine. So this is what happens on the one hand. And then on the other hand, it's an extension over members of jihadist groups. And here, whereas in the first place, on the one hand, with the international legal order and the way in which states are tamed through drone programs and the accompanying legal rationales, you can still identify the norm, you can still recognize the norm. So it's the case with unwilling and able. It's a way in which you attribute to the host state the threat that is posed by a non-state armed group. So this is for the one scenario. Under the second scenario, and the way in which norms are used in order to combat jihadist groups, you see that norms are interpreted in such a way that they are hardly recognizable. So I make an argument about how extensive interpretations of the norms are likely to be when we are outside the realm of equal enmity. So when we are outside what is considered as equal partners in the international legal order, and when it comes to infinite enmity, which I argue is the case when we look at the relationship between states and jihadist groups. So if not equal enmity, I argue that these norms that I study are based at least on mutual acceptance. And this, I argue, is the reason why the legal constructs that we see addressed to other states in the international legal order are still interpreted in in a way that allows us to recognize the norms. And on the other hand, I argue that it's not the case when it comes to infinite enmity or lack of mutual acceptance between the different protagonists. So in the epilogue, and I don't want to be much longer because I would really like to have a conversation with you. In the epilogue, I retrace the explanations of why this exacerbation of state power resting on enhanced technological capacities and reconstructed or deconstructed legal frameworks is taking place. And I suggest that, as I was saying now, that this techno-legal phenomenon is taking place in such a way because of the infinite enmity that characterizes the relationship of states and transnational jihadist groups. So to conclude, maybe very briefly, because this can appear as very specific or niche to drone programs, but I believe that more general takeaways can be reached by looking at the study. And in particular, I think that it talks about how the techno-legal life can look like in the counterterrorism context, how it can be constituted by different legal spaces, on the one hand, placeless digital networks, and very localized actors and phenomena. So I think it's something that can allow us to think further about how the way in which bodies and individuals are regulated in the counterterrorism context is not doesn't escape the grip of the nation state, but rather is a moment of redefinition or of entanglement of different spaces, different bases, and where the state becomes a site for foundational transformation that are accelerated by new technologies, and particularly salient when it comes to the relationship between states and jihadist groups, I believe. Thank you very much for your attention. I'm really looking forward to your questions and comments and to unpacking several of these things as well, if you want.
Thank you. That's great. I look forward to reading the book, and it covers a wide range. And it strikes me at this point off that there's topics like this. There was a lot of writing on drones a few years ago. And maybe initially my sense would be, well, that's kind of being covered. And I think what your argument today suggests that it really hasn't, and that there's still all kinds of bits and pieces that we're still trying to work through and that are quite dealing. So I plead a bit guilty, in fact, as one of the people who's, I was kind of really struggling with whether there's anything specific about drones. And I think there's something. I think we're probably in agreement, but it's partly with drones, it's partly what you do with them. It's a complex mix, but of course, what you do with them is conditioned by what drones are, right? So it's very difficult to disentangle the two. So I have a few thoughts about maybe I wanted to briefly chat. So one is just I'm always interested in Canada. And this is some of our most famous philosophical products. One of the Marshall McLuhan and the idea of a medium is a message, right? And so thought of drones as a mode of communication, right? What kind of message are they communicating? And of course, they're communicating a message through, what they actually, the targets and the targeting, etc. But also just by virtue of being what they are and only being able to deliver certain messages in a certain way. So, this idea of the kind of envelope is just kind of as important as the content, strikes me as one that has obviously a certain genealogy. So there's a couple of things which I'm sure you cover in the book, but which just come to mind. So quite often you talked about the frames, sort of competing frames of the use in bello and the use at bello. And I'm sure you mentioned this. I mean, one of the issues we have with drones is actually the fusion between the in bello and the ad bello, and that every strike is both a humanitarian, potentially usable weapon, but also a mini war, right? A mini armed conflict. There's a whole kind of literature on this, and whether the first strike in itself constitutes an armed conflict, or whether, and in fact, so one thing that really strikes me about drone strikes is the asymmetry. So there's another word that I didn't hear, but it's just intuitively, but the thing about drones, and this isn't entirely new, like the whole point of weapons is that they allow you to target the other without being targeted back, right? So Russia now is using ballistic, missiles from Russia, using a kind of technological capacity that Ukraine doesn't have. But there is something to the fact that drones have been used, at least in not the kind of war on terror context, in ways where the target could never respond, right? I don't know. So there's something about that symmetry. The other kind of element that I did hear, but again, I'm sure it's in the book somewhere, is the competing form of human rights, right? And people like Kahneman and others who make much of the idea that drone strikes are kind of extrajudicial executions, so they should be treated as such and not as just a modality of armed conflict. So these just, I know I'm sure you're aware of all this, and just little touches, right? I mean, it's all about what gets emphasized and what doesn't. Now, so I had a couple of notions. One of them is the role of the host state is really quite interesting, and I think there's often a bit of an ambivalence. So, I think sometimes the host state is protected, like it doesn't want foreign states to use drones on its territory. Not necessarily though because it wants to protect certain groups, but because it wants to protect its sovereignty. But I think we also have cases where states turn a blind eye to what's happening on their territory. I think Pakistan is a good example of that. I think on one hand, nodding at public opinion and saying, "Oh, it's so shocking." On the other hand, letting things happen. I don't know that well enough to make that claim empirically, but so that's interesting. The co-constitution or the co-production of sovereignty, over the dead bodies of terrorists and individuals. I think there's something to that, right? And like we forget that sovereignty is also about who you get to invite on your territory, who you allow, who you empower. And I have a couple more points. One of them is I think towards the end you're saying, I think this has lessons for other areas of, I guess the use of violence and the deployment of violence internationally. Thinking there's really something there, right? And so what about nuclear weapons? Right? So I guess there's a lot of literature already on how the very existence, this is a classic case, right? The very existence of nuclear weapons has completely changed our conceptions of the use that little be used in bello, the advisory opinion of the ICJ, etc. So, maybe drones have that kind of productive role. Everyone knows, I guess, the drone is an emblematic weapon of the war on terror. So the question is, to what extent does the war on terror produce drones? To what extent do the drones produce the war on terror? And I know it's a false dichotomy because they kind of both really implicated. But weapons, I really take the point. The weapons really have a specific way of making certain things possible that we didn't think before. And I have one last comment, which is more of a comment, slash question. The interesting thing that's emerging now about drones. So, there's 2001 to like 2015. So drones require sophisticated technology and are a weapon of the power. But what's happening in Ukraine right now, is these Turkish drones, etc. you realize that actually drones could be a weapon of the week, right? But they're remarkably effective against conventional, tanks, etc. And so here I've got two thoughts about, there's drones in Yemen, there's drones being used now everywhere, right? So how would that change your perspective from, kind of something that France, the US, the UK, Israel do, to something that everyone is doing, potentially to great effect. Now, there's two things. So that first, there's kind of drones in the global south, weapon, and the remarkably cheap. Like, you could jump. You don't need to develop an air force. I mean, probably in the next 20 years, people will states that traditionally didn't have much of an air force will go straight to the drones, right? Because the surplus of actually having a human in a plane is absolutely huge compared to what you can achieve, right, with the drone. So they're going to be popularized and democratized. And the other thing, of course, is non-state drones. Right? So what about terrorist drones? Whatever you want to call them. Now, I think those exist already. I think in Syria there were groups that were using drones, including little technologically maybe unsophisticated things, but contraptions that were deployed against the Syrian army. And that again is interesting. It's like if you think of Freudian terms, like what does that say? Like, okay, you tend to think of these technologies always reinforcing the power of the state. But what if they undermine it? Right? Why did they allow considerable leverage for non-state groups to conduct surveillance operations? You understand sometimes they won't have bureaucracy. Although, if the Daesh kind of had bureaucracy, you can imagine imagine this as part of state building projects. You kind of build dans la profondeur what the kind of systems you want to use for why to develop. That would be an interesting kind of concluding thing maybe it's already there, right? But a little sprinkling of evidence on, whether kind of non-state groups are different, or whether just the nature of the weapon is such that and even in terms of their legal doctrine, such as it may be, using Bellow. Anyhow, so no, I think it's great actually that this book will soon be coming out. I think that people, as I mentioned, people now everyone's moved on to COVID or Ukraine or whatever, and forget that the war on terror and no more emblematic manifestations of drones continues to be just a reality for a lot of people in a lot of places. And it's not going to go away simply because it's maybe not as fashionable intellectually as it was. And of course, it's great that you're doing France because otherwise all of this is so dominated by Anglophone scholarship and just a few countries.
Thank you so much. Thank you. May I react to what?
Sure.
Yeah. No, this is a great set of comments. So thank you very much for the super high quality engagement. A few thoughts because it made me think a little bit further about certain points. So on frames and the fusion of frames, I think this is really crucial to understand more broadly how global governance architectures, be they domestic security practices, or so traditionally understood as domestic security practices, and international ones, beyond the use of force, leads to an overlapping of frames. So it's not just the case for in bello and ad bellum, where you can see indeed how we can trace almost use in belloization of use ad bellum. So beyond the points that you mentioned, it's quite striking how then when the right of self-defense is used on not on a punctual basis anymore, but on a regular basis against individuals who don't participate in armed attacks, but who are identified as carrying a hostile intent, it equates to being part of a non-state armed group that is taking part in an armed conflict. So it's the use of the paradigm of ad bellum to do something, in fact, that resembles identifying individuals that are part of an armed conflict. And it was used in a rhetorical way, actually, because it was not fancy and not attractive at all, and quite controversial to use the in bello paradigm to talk about a global war on terror. So this is the reason why the Obama administration had a lot of recourse to the ad bellum framework to do, in fact, something that was very close to justifying or to regulating the use of force in an armed conflict. So this fusion of frames, of course, exists, and I would push it even further to talk about how it's a lesson for other fields and other modes of violence. So not only the use of force. If you talk about, if you look at the drone program in a way that goes beyond the targeted killings and the use of force, you understand that it's very much about, in fact, new modes of governance in the security or in the collective security system that goes through collection of data. So I think this is also what differentiates my study from others, is that then we can talk about other weapons, as we did, and I think you're absolutely right in your reflections on nuclear weapons. But then we can talk also about watch listing practices that are
about what?
watch listing practices. So other modes of violence and other modes of controlling bodies in order to anticipate threats. And this leads, of course, to not only a blurring of international frameworks with one another, but also of what we consider as traditionally, I think, international law and domestic law, for example. And this whole emergence in the law of the enemy as well. And this probably leads me to connect this reflection with the last part of your comments, which I think is crucial. And what do we make of the use of drones by other types of actors, but also by other states in the global south, for example? One that is yet to come, though, in such an intense and sophisticated manner. First of all, I think what differentiates the use of drones by this handful of state I look at, and the other actors currently using drones in a more intense manner, is again, it's the data or the surveillance apparatus that comes with it. So in the end, when you look at the book and at my argument, it's sometimes much more, actually, I think much more about the data collection system that it comes with, rather than the targeted killing practices. It is part of the story, but it's just a small part of the story. However, I think it's quite important indeed that I add actually some reflections on this issue, because it's pretty much of a history of the present, as I started with. So it's not excluded that in the near future, the same kind of data collection systems are put in place by other states that are less weak in the international legal plane and in the international legal order. So it might be that then similar stories or similar histories or genealogies of the present can be told about other modes that are other modes of data collection systems or watch listing systems that would then, of course, make this analysis not valid anymore. You know, I don't exclude this at all. I love the idea of drones as a mode of communication. So thanks a lot for this, because I think what is the most powerful thing in drones, and this is probably why it's also understudied when it comes to France, because when you look at the US, it was made public, right? There was a conscious choice of policymakers to craft this legal rationale in a very public manner, in a very visible manner. But otherwise, drone as a mode of communication is quite discreet. So it's the invisibility of drones as a mode of communication that I think is quite powerful. So I really love this idea. Yeah, thanks a lot. I didn't do justice to all your comments, but I really took great notes of it.
Cool.
Yeah, no, but very, very helpful.
He wants to chip in.
Adam. Yes, yes, all of the drone technology very developed it's still exposed to the public violation of
Sorry, I didn't get this.
yes, I still exposed to the possibility of violation of the kind of regulation. Well, the impact of the principle of distinction, so principle of proportionality. What do you think about this problem? And is there any efforts to overcome this problem in the US or program tools?
Thank you so much. Should I collect several questions at a time?
Well, whatever you want.
No, go ahead.
Information for both and inspirations. Just mentioning some case study in the US, just wonder distinctions when you find some probably distinctions or similarities and also I think you mostly doctrinal science from distinctions. I just wondered what's the methods that work narratives, stories from these.
Thank you so much. Thank you for this great questions. So if I understand your first question well, and the question of malfunction, so is there still a risk of malfunction of the technology that would lead to an inherent or to drones inherently by definition because of their construct or their violate rules of IHL, for example. This, to my knowledge, is not the case. So drones in and of themselves, and that's what has shaped the conversation in legal scholarship, actually. Drones in and of themselves do not violate international humanitarian law. So they are, it is possible to respect the principle of distinction, to respect the principle of proportionality through the use of drones, because nothing in their technology prevents it. So this is the first thing I want to highlight. And maybe then I would like to suggest that your question might be influenced by other types of weapons and autonomous weapon systems that do not have drone operators, human in the loop, that would make ultimately the decision. So when we talked initially about the different types of weapons that might attract our attention in the near future, you have, of course, AI decision support systems. So systems that consist in or that are assisted by AI that collects evidence, that collects intelligence, and that then would point to a certain direction to the human operator. So this is the most foreseeable future in terms of AI on the battlefield, artificial intelligence on the battlefield. And in that case, there is, of course, a discussion to have about the not necessarily malfunction, but a black box issue of the fact that it's impossible to understand what the algorithm or why the algorithm points towards a certain direction when it comes to making a certain decision on the battlefield. So I'm thinking that maybe your first question, is more related to this type of more elaborate systems that have a certain degree of autonomy into them. This is just a thought. And then on the principle of distinction and continuous combat function, I think, and the potential solution that I have, you must have, or you might have understood that this is not so much a study that contains normative discussions. So I'm not arguing in favor of certain solutions, which might be frustrating when you look at or when you read the book, but it's not what it is. It's an exercise in describing in the most granular manner what has been created, what emerges from a certain military strategy using certain tools and built or based on rationals. But it doesn't contain a normative agenda. However, I have written a piece very recently that will appear in the International Review of the Red Cross. When I do something that I have prevented myself from doing in the book, which is to propose a certain interpretation of the continuous combat function in a way that is more normative. So I'm not arguing that it's the right interpretation of the norm or the true interpretation of the norm, but that it's a desirable one when it comes to curtailing or constraining state practice in that regard. And my point is that as long as the continuous combat function test can be positive, which is can lead to the identification of someone as holding a continuous combat function without having ever witnessed participation in hostilities, as long as it's the case, then the state practice will be potentially problematic and contain a high error risk, because this is what it is. It puts civilian populations at greater risk. So this is in terms of doctrinal solutions. And then on your great questions on US, UK, and France, the reason why I picked those three is that to date, these are the most elaborate uses of drones in an extraterritorial way, so extraterritorially, transnationally, against jihadist groups, or what is called Al-Qaeda and associated forces in the US. So this is the reason why I picked those three cases. In terms of similarities, they are much greater than anyone would like to admit. So for a long time, it has been argued that the US drone programs was very problematic in many ways that differed from the UK and France legitimation or justification to use drones. On the contrary, I show that the US legal rationales have influenced both French and UK representatives in a greater manner than anyone would like to admit. When it comes to legal rationales, when it comes to the military strategy that accompanies the use of drones. So I would like, of course, I cannot unpack this too much for the sake of your afternoon and of preserving your time. But what I want to highlight here is that the similarities are much greater than what we would think. And that sometimes, as I also try to point out, it even goes beyond what has been proposed in the US when it comes in France to this framing of the enemy as being jihadist groups, which is, of course, calls for or potentially leads to an even more extensive warfare in time and space. And the proof is, of course, that the intervention in the Sahel has been ongoing for almost 10 years already. The greatest difference, however, because the greatest similarities lies in the type, the military strategy and the legal rationales, the greatest difference is the degree of institutionalization that I haven't been able to trace in the case of the UK and in the case of France as much as in the US. This might be because, factually speaking, it's less of an institution, it's less of a bureaucracy, but it might also be because I don't have access to documents. Because in the case of the US, I build on documents that were leaked by the Intercept, as I mentioned. So yeah, these are for the main similarities and main differences. Thanks for the question.
Thank you. Actually, my colleagues helped with the crowd and questions. You obviously gave pretty extensive answers. So for my side, a lot of it was just I think conversations which you have another better more like conversation that are listed. I'm just wondering, how to extend the so one thing I want to say is the law really taking this consider your aspect justifying see there is that substantive difference and the degree of success compared to the Bush era, war on terror series on that visual narrative, and then after the Obama administration, with legal narratives. The other one I really thought that it's already thought form is just a piece of forms in that in many ways this that kind of like mesh of the all been if the technology does enable it, if one day drones enable non-lethal strikes, our states obligated to do so on the basis of humanitarian rights. I really like the forever war slash angular war kind of model of that, just like Albert's idea of time space. I think there's something called AI really pushing all that point. Technology is not so on the idea that, hey, you know what, if I have a hammer, it's a nail. If I have like a nail gun, it changes the rules, right? It's not just, oh, it's just the same thing with basketball. No, there is certainly very visceral kind of impact that they have. And so, one question I have also that, because I kind of project is somewhat similar. How do you use sources, especially on the military side, and what do you find most successful challenging?
Yeah, these are great questions. Thanks a lot. Yeah,
I was particularly interested about the point that you made about legal scholarship, that in general, the focus is on the 1% about the actual decision to deploy the path. And there's a lot of silence around the 99% of what these people actually end up doing. So there's a lot of data collection and observation. And I was kind of thinking, because I study different aspects of data collection that don't involve drones, but I was very interested in asking you. So I was thinking about this data collection through the use of drones as a form of both positive instrument to a degree for civilian population on the ground, as well as a negative one. As a positive, we could say that the more information is collected, more likely it is that a target is going to be actually the correct target, if you could call it that. So the point would be that the drone will not then strike civilians that are not involved in activities. And from the negative perspective, however, I think that the aspect of what is called in, I think, media, it's a media theory and communication theory called data colonialism. So there's the idea that the collection of data in certain populations, especially in developing countries, it's a population that cannot say no, essentially, to this data collection, is collected for the purpose both of business, but also of the national interest of foreign countries. And at the same time, when you mentioned that not only data collection is done sufficiently to actually be able to assess whether a subject is in fact a non-participant into the conflict. So is it really is it really worth it to kind of look at this from the lens of, well, it's a protection, but is it in the end of the whole analysis of it?
That's great points. Thanks a lot. So these are all very interesting points that you made on the academic projects. So seeing this design and crafting of legal rationals and sophisticated legal narratives as an academic project, and how it differentiated also the Obama administration from the Bush era. Of course, you make a great point here. I don't take it as a question. Sometimes we frame things as a question, but I think you're making just a great point, which is that we left the era of exceptionalism, where the idea was that, and there has been a lot of scholarly work on the question as well. How do we differentiate that? So of course, it changes everything in terms of frame and narrative, and that's what makes it so convincing and acceptable as well. It's the whole idea of soft power through the elaboration of legal rationals. So this is the first one. I think it's a great point. The second is, your point on forever and anywhere war and how AI influences or exacerbates these phenomena, if I understand your point correctly. I would just add to this other great point that you made, that we see indeed an increasing, through AI tools, an increasing blurring, and that's why I open up the discussion a little bit to all kinds of security practices that are based on data collection systems. And we see a blurring of traditional categories, a blurring of war and peace, a blurring of battlefield, non-battlefield, a blurring of criminal enemy, a blurring of combatant, non-combatant. And I think that this is all exacerbated by the technology and the legal narratives that accompany it. On your question on sources and the challenges that I've faced, of course, as you mentioned it yourself, when it's when you do empirical work in the security realm, it's quite difficult to actually use the empirical material that you have gathered. So I've spent 6 months in New York collecting or conducting interviews with people who had participated in the Obama administration, with also drone operators that accepted to discuss and speak with me. I harassed them a little bit, but it worked. And none of it appears in the book. So everything was just used for me to corroborate hypotheses and feel comfortable as a researcher to formulate certain reflections and put forward certain hypotheses. And I say hypotheses, although I have confirmed some of them, but they all appear as hypotheses. So it's I guess, a groundwork that wouldn't have allowed me to put some things or to think about those issues in the way I do. That's why they are crucial. But of course, it's challenging when you're in front of your computer and then all of a sudden you would like to quote directly individuals with whom you have discussed, sometimes at length, and that you're not able to quote for obvious reasons. Still, I do believe that this book wouldn't look like it does if I hadn't conducted this empirical work. So I think it's interesting because then it's a kind of exercise in compilation. I assemble different kinds of materials and I try to corroborate the hypothesis with all kinds of materials. But I'm happy to discuss about your project if that's helpful, because I do think that with the book I make an intervention in terms of methodology. I propose a kind of investigative academic work, very close to journalistic work, actually, when it comes to empirical evidence. On data collection, I really love the concept of data colonialism that I haven't used in my work so far, but I think it's a very interesting literature. And your identification of it as being a positive instrument and a negative one for different reasons, I think it's, of course, good food for thought. And the rationale that it might be a positive instrument, it has been argued a lot that this is a precision tool and that therefore it's a positive instrument in order to achieve the aim of anticipating threats. However, what I show is that we overestimate what the data allows us to do. And this is what leads to a high error risk, is that oftentimes you won't have, and this of course is, again, goes back to the techno-legal machinery. When you have on the one hand the technology that allows you to do something, and on the other hand, legal creations such as the continuous combat function that allows you to target an individual, even if you haven't witnessed his or her participation in hostilities, the two combined together will lead or leads, at least on some occasions, operating states not to wait for the moment where they would reach perfect certainty. So the tool is not actually used in the way in which you propose it could be, and in a positive manner would be used. But rather, you see that there is a rush into the decision-making of striking, of conducting the strike, because we overestimate what the technology allows us to do, and we have legal frameworks that allow us to do certain things. But thanks a lot for all your really precious feedback and great engagement. I'm really glad we've had this